Ways, top of the top. Welcome to the DAMU KIWE conversations. You know what I'm saying? Hey, look, I don't know about y'all. We've been waiting on the work to come. Well, it sounds like Bricc not the trade that signed the plea agreement. No contest. And we're going to get right to that. But before we get to that, it's early in the morning. I don't know when I'm going to release this, but it should be released by today. But we're going to paperwork party. Bricc not the trick. You know what I'm saying? Documentation. Now, mind you, let me make sure for those who don't know, let me close this. Hold on. Let me stop sharing this. I want to wake up on a positive note, man. Good spirits for the bro. You know what I'm saying? We gonna get this one going. You know, wake your cold mouth ass up early in the morning.
We're gonna go on DAMU KIWE conversation. I'm gonna do an interview on DAMU KIWE conversation. We're gonna go on DAMU KIWE conversation. I'm gonna do an interview on DAMU KIWE conversation.
So there you have that. You know what I'm saying? But we do have the paperwork, and it's ironic as it relates to Big U's indictment that it's early morning. I'm recording when I read through this paperwork party because every morning that's when we would talk. You know what I'm saying? We catch him, you know what I'm saying, early in the morning because I'm an early bird. Some people who's been compromised before already, you know what I'm saying, they be on the phone. Even Spiderloaf would be on some of the calls, Yael, Scandalous Los Angeles, and we would build tiny draws, Credit Cali Acclaim, Bomani, Big Messy Moore, even introduce Munchie B to Big U, you know what I'm saying? And we will have these conversations where we build positively about our community, not this online negative shit that seems to bring no fruit to bear. You know what I'm saying? Like everybody talking about the problem, and you need to analyze the problem before you come up with a strategic measure to move forward that you implement. But at the same time, we got people that's already, y'all behind the cue ball, we got people that's out here active in the community positively. So Bricc not the trick. Zaire Mitchell, man. You know what I'm saying? Everybody talking about Bricc was a rat. I don't do that speculation, bro. You know what I'm saying? I know he gonna rap, bro. You don't know what a nigga gonna do till he up against it, nigga. And then people offering them deals and sweet nothings and whether then you're gonna see what's at the core of that person's heart. You gotta conduct bypass surgery, and that only happens through surgery, which is friction with the laws. You know what I'm saying? Y'all be so quick to try to say everybody a rat just because the pussy ass niggas you deal with is rats. Just because you know if you get caught doing something you ain't supposed to, you gonna rat. Some people is different. You know what I'm saying? And so I get benefit to the doubt, even to my ops. You know what I'm saying? Until the motherfucker got proof. Now, for those who don't know, just because he signed this deal and if it doesn't have anything which means that he cooperated with law enforcement, doesn't mean at sentencing that we can't find out that he might have talked about another case, cooperated on another case, because for sentencing, he'll be trying to get reductions if he was cooperating for sentencing reduction. But the deal that they offering him don't sound to me like it's some kind of snitch deal. It's a plea agreement for defendant Zaire Mitchell, Bricc Baby, Big Shitty, MPA Shit Dro, Shitty Montana, Bricc Baby Shit Dro. This constitutes the plea agreement between Zaire Mitchell, also known as Bricc Baby, aka Big Shitty, aka MPA Shit Dro, aka Shitty Montana, aka Bricc Baby Shit Dro, and the United States Attorney's Office for the Central District of California, same district I was sentenced out of. In the above captured case, this agreement is limited to the USAO and cannot bind any other federal, state, local, or foreign prosecution, enforcement, administrative, or regulatory authorities, right? Defendant's obligation. Defendant agrees to, at the earliest opportunity, requested by the USAO office and provided by the court, appear and plead guilty to count 2 of the indictment in U.S. versus Zaire Mitchell. CR, and that's the case number, which charges defendant with being a felon in possession of a firearm with ammunition in violation of 18 U.S.C. 922G1. So we're going to go up into that also, and we'll break down exactly what that is. That's the gun case. 922G is possession. 922 is possession of a firearm. 922G is, I think, like a assault weapon, which adds for more time. You know what I'm saying? Let me see what it say. Boom. Who is prohibited. All right, so federal law, let's go up into this so that you guys is all with me. I can't just take for granted everybody understands what's going on. We all laymen, you know what I'm saying? My experience as a criminal kind of better positions me. Okay, so federal law imposes strict restrictions on firearm possession with 18 U.S.C. 922G, making it illegal for certain individuals to own or possess firearms, primarily targeting those convicted of serious crimes. So that's an ex-felon with a crime, just to keep it simple, right? Short and simple. So we'll get back to the paperwork. So that's what Bricc could be pleading to if accepting this deal. I'm thinking he already accepted the deal. But we'll see the bottom and make sure he signed. All right, so not contest facts agreed to in this agreement. So once he said he's guilty, he won't contest any of the facts as outlined in this agreement. Abide by all agreements regarding sentencing contained in this agreement. Appear for all court appearances, surrender as order for service of sentence, obey all conditions of any bond, and obey any other ongoing court order in this matter, not commit any crime. However, offenses that would be excluded for sentencing purposes under U.S. sentencing guideline are not within the scope of this agreement. Be truthful at all times with the United States Probation and Pretrial Service Officer and the court. Pay the applicable special assessment at or before the time of sentencing, unless defendant has demonstrated a lack or of ability to pay such assessments. Defendant further agrees to forfeit all right, title, and interest in and to any and all monies, properties, and or assets of any kind derived from or acquired as a result of or used to facilitate the commission of or involved in illegal activity to which defendant pleaded guilty, specifically including but not limited to the following: a Ruger model LCP 380 caliber pistol bearing serial number 379057941. So that's the burner that they got on for, at least one of the burners that they got on for, and that's a 380 Ruger, right? A Canic model TP9 SF 9mm caliber pistol bearing serial number 19A200966. A Radom model Hellpup 5.56/45 caliber pistol bearing serial numbers PAT 117473522. 4. 26 rounds of Cascade cartridge ink, 9mm caliber ammunition. 32 rounds of Cascade, 32 rounds of Lake City, 5.56. 5.56, you know what that is. Caliber ammunition. If you don't know what that is, that's a good thing. You've been privy not to have to know such things, not to have to fear such things. 6 rounds of Giulio Fiocchi Lecco, 380 caliber ammunition, 31 rounds of Remington Peters, 5.56 caliber ammunition, 36 rounds of Hornady 5.56 caliber ammunition, 1 round of Spear 4.5 caliber ammunition, and 1 round of precision-made cartridges 4.5 caliber ammunition, collectively the forfeitable property. So all of that together, he got to relinquish all of that property is forfeitable as part of this agreement if they don't already have it. And if they do have it, he's waiving his right to it. To the court's entry of an order of forfeiture at or before sentencing with respect to the forfeitable property and to the forfeiture of the property, that the preliminary order of forfeiture shall become final as to the defendant upon entry to take whatever steps are necessary to pass to the United States clear title to the forfeitable property, including, without limitation, the execution of a consent decree of forfeiture and the completing of any other legal documents required for the transfer of title to the United States. E, not to contest any administrative forfeiture proceedings or civil judicial proceeding commenced against the forfeitable property. If defendant submitted a claim and or petition for remission for all or part of the forfeitable property on behalf of himself or any other individual or entity, defendant shall and hereby does withdraw any such claims or petitions and further agrees to waive any right he may have to seek remission or mitigation of the forfeiture of the forfeitable property. Defendant further waives any and all notice requirements of 18 U.S.C. subsection 983A1A and all requirements of the government to commence forfeiture actions pursuant to 18 U.S.C. 924D1. Not to assist any other. See, D1 is a different element, which would be more because I had a 924C. So I'm thinking the 924D is going to be for the chopstick. You know what I'm saying? I think that's going to be for, all right, so 924D. Let me see. Oh yeah, that's how they remove firearms from individuals who have used them unlawfully. So yeah, they confiscating the Bricc, my nigga. Not to assist any other individual in any effort falsely to contest the forfeiture of the forfeitable property. Not to claim that reasonable cause to seize the forfeitable property was lacking, to prevent the transfer, sale, destruction, or loss of the forfeitable property to the extent defendant has the ability to do so, to fill out and deliver to the USA office a completed financial statement listing defendant's assets on the form provided by the USAO. That forfeiture of forfeitable property shall not be counted towards satisfaction of any special assessment, fine, restitution, cost, or other penalty the court may impose. Okay. With respect to any criminal forfeiture ordered as a result of this plea agreement, defendant waives 1, the requirements of federal rules of criminal procedure 32.2 and 43A regarding notice of the forfeiture in the charging instrument, announcements of the forfeiture as sentencing, and incorporation of the forfeiture in the judgment. 2, all constitutional and statutory challenges to the forfeiture, including by direct appeal, habeas corpus, or any other means. And 3, all constitutional, legal, and equitable defenses to the forfeiture of the forfeitable property in any proceeding on any ground, including, without limitation, that the forfeiture constitutes an excessive fine or punishment, defendant acknowledges that the forfeiture of the forfeitable property is part of the sentence that may be imposed in this case and waives any failure by the court to advise defendant of this pursuant to Federal Rule of Criminal Procedure 11B1J at the time the court accepts defendant's guilty plea. Hold on. Gotta wet my whistle. The USAO agrees to A, not contest facts agreed to in this agreement. B, abide by all agreements regarding sentencing contained in this agreement. C, at the time of sentencing, move to dismiss the remaining counts of the indictment against defendant. Defendant agrees, however, that at the time of sentencing, the court may consider any dismissed charges in determining the applicable sentencing guidelines range, the propriety and extent of any departure from that range, and the sentence to be imposed. D, at the time of sentencing, provided that defendant demonstrates an acceptance of responsibility for the offense up to and including the time of reduction, recommend a 2-level reduction in the applicable sentencing guideline offense level pursuant to U.S. Sentencing Guidelines subsection 3E1.1, and recommend, and if necessary, move for an additional 1-level reduction if available under that section. I'm praying that the brother get the 3-level reduction instead of just a 2-level reduction, but that's all up to the judge now. Ever since Booker versus Washington unbinded the judge's hands, they have a lot more power, and when it comes to sentencing, to deviate from the U.S. sentencing guidelines, as long as they're able to justify by the law. That's customary for people who take plea agreements in the feds to get a 2 or 3 point reduction for acceptance of responsibility. Acceptance of responsibility of your actions, not cooperating, putting responsibility on someone else. Except for criminal tax violations, including conspiracy to commit such violations chargeable under 18 U.S.C. subsection 371, that's conspiracy. Not further criminally prosecute defendant for violations of 18 U.S.C. subsection 1343, wire fraud, 18 U.S.C. 1040, fraud in connection with a major disaster or emergency benefits, and 18 U.S.C. subsection 287, false, fictitious, or fraudulent claims arising out of defendant's conduct described in the agreed to factual basis set forth in paragraph 10 below. Defendant understands that the U.S. Attorney's Office is free to criminally prosecute defendant for any other unlawful past conduct or any unlawful conduct that occurs after the date of this agreement. Defendant agrees that at the time of sentencing, the court may consider the uncharged conduct in determining the applicable sentencing guideline range, the propriety and extent of any departure from that range, and the sentence to be imposed after consideration of the sentencing guideline and all the relevant factors under 18 U.S.C. subsection 3553A. The nature of the offense. Defendant understands that for a defendant to be guilty of the crime charged in count 2, that is, felon in possession of firearms and ammunition in violation of Title 18 U.S. Code Section 922G1, the following must be true. First, the defendant knowingly possessed, so it's an intent crime. You had to know that you had this burner on you, right? Knowingly possessed a firearm or ammunition. Second, the firearm or ammunition have been transported to interstate commerce. That means that it wasn't made in California and it crossed state lines. That gives them the jurisdiction to hold you accountable for being an ex-felon in possession of a firearm. Once it crosses interstate commerce, the feds have opportunity, and it's up to them to take jurisdiction over such crimes. Third, at the time the defendant possessed the firearm or ammunition, the defendant have been convicted of a crime punishable by imprisonment for a term exceeding 1 year. And fourth, at the time the defendant possessed the firearm or ammunition, the defendant knew he had been convicted of a crime punishable by imprisonment for a term exceeding 1 year. Penalties. Defendant understands that the statutory maximum sentence that the court can impose for a violation of Title 18 U.S. Code 922 G1 is 15 years in prison. So his max is 15 years. Let me tell y'all this. A maximum for a crime isn't equated to what the U.S. Citizen Guideline does, whether it's the base offense level going down, and then it accounts for your criminal history going across. So going across, you have criminal history category 1, 2, 3, 4, 5, 6, all of that, and then going down to be the base offense level for this crime, right? The base offense level, we can figure that out real quick. I don't know what criminal history category he in, because his what is the base offense level for 922 G1. All right, so we finna see what that is. So his base offense level so the okay, all right, so 922G base offense level. It ranges from 6 to 26 points. So I'm gonna show y'all how the sentencing guideline look, because I'm just talking to y'all. So from 6 to 26. So let's go like this. United States sentencing. What is that called? Chart. Let's see if we can get the chart real quick. Yeah, here it go, right here. We're gonna show y'all this. See the little things that I did learn in the feds help me to help y'all better understand. I know most people wouldn't have a clue, but here goes the U.S. sentencing guideline chart, the sentencing table. So when I was saying the criminal history category, that'll be right at the top, right? The sentencing table, you see criminal history category, and then there'll be a criminal history category points. If you don't have any and little to any criminal history, you'll be over here, which is best. This, if you're the criminal being sentenced, you wishing and praying that you have no history. But if you do, you have so many points, 2 or 3 points would be 2, 4, 5, or 6 points would be criminal history category 3. That's where I was at. 7, 8, or 9, you'll be criminal history category 4, 5, 13 or more points, you'll be criminal history category 6, which is the most time. So remember, Bricc points for his crime start at 6 points, which means that even if he's criminal history category 6, which is the worst one, he could get sentenced if the judge decides at 9 to 15 months. Bricc could get sentenced to from 9 to 15 months. Don't mean that that's where the judge is. Oh, no, hold on. 6 is right here, my bad. 12 to 18 months, right? If he's criminal category 6. But if he's criminal category 3, he could get 1 to 7 months for them blammer. But it's all up to the judge, or 2 to 8 months, my bad, 2 to 8 months. It's all up to the judge. And I think they said up to 26 points. So 26 points would be, now this is kind of like where it's going to be, right? If he's criminal history category 6, he's facing anywhere from 120 to 150 months. Y'all know how long that is? That's 10 years. If the judge sentenced you to the low end, 10 years is 120 months. Add 30 months to that, that'll be 12 years and some change, right? If he's criminal history category 6. Now, if he's criminal history category 1, because he never been to the pen, then he's somewhere between 63 months and 78 months. So 70 months is 5 years, 10 months. So you basically saying 6 years, 6 months or something like that, if he's criminal history category 1. So his criminal history category is definitely going to play a role in it. But I just want to give y'all an idea of the low end if the judge gives him 26 points. But remember, they're going to depart 2 to 3 points. So let's say 2 points. So from 26 to 24 points, right? If they depart, that would mean that the most he could get is 10 years, 5 months. If the judge sentenced him to the high end, maybe they don't believe he has exhibited any kind of remorse for victims, or he did something excruciating that rubbed on his case that rubbed the judge wrong, and they said, well, we're going to give you the 2-point reduction, but we're going to sentence you to the high end. That would be 10 years and 5 months. So really, as long as he gets at least the 2-point reduction, sentencing reduction for acceptance of responsibility, the most he's looking at is 10 years, 5 months. The least he's looking at is 51 to 63 months. 51 months ain't bad for the chopstick and the other burner. That'd be a real good deal if he didn't have to rat. That'd be a real good deal. Now, if you get the 3-point sentencing reduction, the most he'll be facing is 115 months. That's 9 years, 9 years, 7 months if he gets the high end. But he could get 92 months, right? Which would be 84 months to be 7 years plus 8. So 7 years, 8 months if he gets the low end and the 3-point reduction. If he's criminal history category 1, then he will be at 46 to 57 months. That will mean that he's eligible for the drug program. We all know he liked them perks and liked the SIP. So he could go do the RDAP, the Residential Drug Abuse Program. If he completes that, they could take a year. They will take up to a year off of his time, which would mean a year off if he got the low end, 51 months. A year off of that would make it 39 months. That'd be 3 years, 3 months. That would be 3 years, 3 months that he would still have to do. So prayers for Bricc, man. This is what you up against. Where you don't want to be is right here, down here, where you getting 324 to 405 months, 360 years. That's 30 to life. You know what I'm saying? If you get down here, 30 to life. You know, so I hope I was able to educate y'all about what the Bricc is facing in the feds right now for that blammer, a couple blammers. You know what I'm saying? And him being shot, maybe maybe he should shoot his spiel to the judge when they ask him to speak about his crime and accept responsibility. At that point, that's all you can do. Look, I'm not here to talk about what nobody else had to do. I'm here because I want to move on to my life. I owe that to society. I owe that to myself. I owe that to my family, who I victimized by breaking the law and taking myself through this. I want to get it over with so that I could right the wrongs, get towards and rehabilitate myself to right the wrongs and get out there and become a productive citizen in society. Not saying that Bricc wasn't a productive citizen in society. It's just you could be a productive citizen in society and fuck up, man. He fucked up. You know what I'm saying? So he want to get back to that trail, man. Shout out Bricc, not that trade. So defendant understands that the statutory maximum sentence, we already did that. A 3-year period of supervised release. So he'll be on federal supervised release for 3 years. And then a fine of $250,000 or twice the gross gain or gross loss resulting from the offense, whichever is greatest, and the mandatory special assessment of $100. So defendant understands that supervised release is a period of time following imprisonment, right? During which defendant will be subject to various restrictions and requirements. Defendant understands that if defendant violates one or more of the conditions of any supervised release imposed, defendant may be returned to prison for all or part of the term of supervised release authorized by the statute for the offense that resulted in the term of supervised release. 8, defendant understands that by pleading guilty, defendant may be given up valuable government benefits and valuable civic rights, such as the right to vote, the right to possess a firearm, the right to hold office, and the right to serve on a jury. Defendant understands that he is pleading guilty to a felony and that it is a federal crime for a convicted felon to possess a firearm or ammunition. Defendant understands that the conviction in this case may also subject defendant to various other collateral consequences, including but not limited to revocation of probation, parole, or supervised release. In another case, in suspension or revocation of a professional license. Defendant understands that unanticipated collateral consequences will not serve as grounds to withdraw defendant's guilty plea. 9, defendant and his counsel have discussed the fact that, and defendant understands that if defendant is not a United States citizen, the conviction in this case makes it practically inevitable and virtual certainty that defendant will be removed or deported from the United States. Defendant may also be denied United States citizenship and admission to the United States in the future. Defendant understands that while there may be arguments that defendant can raise in immigration proceedings to avoid or delay removal, removal is presumptively mandatory and a virtual certainty in this case. Defendant further understands that removal and immigration consequences are the subject of a separate proceeding and that no one, including his attorney or the court, can predict to an absolute certainty the effect of his conviction on his immigration status. Defendant nevertheless affirms that he wants to plead guilty, regardless of any immigration consequences that his plea may entail, even if the consequence is automatic removal from the United States. Factual basis. 10. Defendant admits that defendant is, in fact, guilty of the offense to which defendant is agreeing to plead guilty. Defendant and the United States Attorney's Office agreed to the statement of facts provided below and agreed that this statement of facts is sufficient to support a plea of guilty to the charge described in this agreement and to establish the sentencing guideline factors set forth in paragraph 12 below, but is not meant to be a complete resuscitation of all the facts relevant to the underlying criminal conduct or all facts known to either party that relate to that conduct. On July 12, 2022, in Los Angeles County, defendant possessed 3 rounds of Spear 9mm caliber ammunition, which defendant fired from a 9mm caliber gun. on June 23rd, 2023. Right? That was July 2022. June 2023, in Los Angeles County, defendant possessed the following firearms and ammunition: a Ruger model LCP 380 caliber pistol bearing serial number. All right. Connect model TP9SF 9mm caliber pistol bearing serial number. Random model hell pump 5.56 caliber. You know what that is? 5.56 times 4.5 caliber pistol bearing serial number, and then 26 rounds of Cascade cartridge ink, 32 rounds of Lake City 5.56 caliber ammunition, 6 rounds of Giulio Fiacchi Lecco 380 caliber ammunition, 31 rounds of Remington Peters 5.56 caliber, 36 rounds of Hornady 5.56 caliber ammunition, 1 round of Spear 4.5 caliber ammunition, and 1 round of precision made cartridges 45 caliber ammunitions. All of the firearms and ammunition defendant possessed on both those days had traveled in and affected interstate commerce. Hold on one second. Hey, I'll call you. I'm reading out the Bricc paperwork right now. So, where were we? I got a text. 1 second. So, all right, defendant possessed such firearms and ammunition, knowing that they had previously been convicted of the following felony crimes: reckless evading. So he had a high-speed chase in the Superior Court in Cali. About that was in 2010. So I guess that's what he went to the county jail for when he was in the county with the homies. 2, possession of a controlled substance in violation of California Health and Safety Code 11 Trade 508. Yeah, that's just a possession. 11 Trade 51 would be distribution or sales, right? In the Superior Court of the state of California, County of Los Angeles, case number blank, on or about December 6, 2012. Possession of a controlled substance in violation of health and safety codes in the Superior Court County. So he got a couple possessions. He keep getting caught with some kind of gang drug, more than likely, because that's what he's an addict. You know what I'm saying? A salute to that brother, man. They say he done blew up and got on swole and put on about 50 pounds since he been down there. It's only been about 6 months. You know what I'm saying? That them drugs was eating them up. But county case number August 2nd, 2016, and 5, robbery in violation of 211 Superior Court around 2020. So he had a robbery in 2020. Separate and apart from defendant's possession of firearms and ammunition as a felon, on February 14, 2025, defendant filed an application for disaster assistance with the Department of Homeland Security, knowingly and falsely claiming that defendant was renting a home in Pasadena, California, that was destroyed by a fire, lava flow, ash, Oh, so he tried to get paid off of the disaster fund out there in Pasadena. Hey, Bricc, you didn't even put me up on that lick, my nigga. I might have tried him too. I don't know why I didn't think about it. But anyway, by doing so, defendant attempted to receive federal FEMA benefits to include personal property reimbursement, loss of primary vehicle, essential utility needs, loss of primary residency, food, clothing, shelter, gas, medical equipment, child care costs, lodging expenses, moving expenses, and storage expenses. However, defendant never lived or rented the home in Pasadena, was not a victim of the Eaton wildfire, which was declared a federal disaster, and was not entitled to any of the benefits or funds he sought in filing the false application. As he well knew, in doing so, defendant attempted to defraud the federal government by falsely claiming to be a victim of the disaster. Moreover, when the genuine homeowner and victim of the disaster attempted to submit a small business SBA disaster loan, it was denied due to defendant's pending false application. Defendant understands that in determining, so they're going to waive all of these other charges that he had pending as part of his agreement. Man, this nigga got a good deal. It's going to really be up to his judge. I mean, consider the circumstances where he might, he could get his life back together. He's articulate, street smart, charismatic, a funny motherfucker, you know? And he knows how to network, man. So yeah, man, this Bricc, not the trick, got action, man. You know what I'm saying? So defendant understands that the sentencing guidelines are advisory only. They advise the judges to utilize the sentencing guideline, but ultimately it's at the judge's discretion what the sentencing is going to be. That defendant cannot have any expectation of receiving a sentence within a calculated sentencing guideline range. And that after considering the sentencing guidelines and the other subsection 3553A factors, the court will be free to exercise its discretion, see what I'm saying, to impose any sentence it finds appropriate up to the maximum set by statute for the crime of conviction. Almost never does a judge give you the statutory maximum unless there's, like I say, there's elements of the crime that piss them off. You did something sexual while doing a robbery, you harmed somebody, and all of those, then they'll be like, yeah, we want, or you ain't got no empathy, then they'll do that. But it's really up to them. And that's what the law states. Defendant, they were binding to the sentencing guidelines prior to Blakely versus Washington. Just a little history on the statutes and the law. Defendant and the U.S. attorney reserve the right to argue that additional specific offense characteristics, adjustments, and departures under the sentencing guidelines are appropriate. The base offense level set forth above is based on information currently known to the government regarding defendant's criminal history. Defendant understands and agrees that defendant's base offense level could be increased if defendant is a career offender under USSG subsection 4B1 or an armed career criminal under USSG. Now, that's why he should have got a pre-sentencing report before he signs this deal. If you ever in this situation, pray that you not. Ask for a pre-sentencing report based on your criminal history before you sign your deal, because you don't want to sign this deal and then they hit you with an ACC, which is an additional 15 years. You know what I'm saying? 15 years. So it could go from okay to ugly real fast. So you want to take those type of measures. If defendant's base offense level is so altered, defendant and the USA would not be bound by the base offense level agreed to above, right? Defendant understands that there is no agreement as to defendant's criminal history or criminal history category. Defendant in the USAO reserved the right to argue for a sentence outside of the sentencing range established by the U.S. sentencing guideline based on the factors set forth in 18 U.S.C. 3553A1, waiver of constitutional rights, and we're going to go through all of those. Understand that when you do waive your constitutional rights, that's the right to persist in a plea of not guilty. You can no longer say you're not guilty of the crime. You have the right to speedy and public trial by jury. It's the right to be represented by counsel. So all of these rights, you're waiving, right? Waiver of appeal of conviction, waiver of appeal of sentencing. All of these are rights that you have. But when you sign the agreement, you're waiving all of those. Result of withdrawal of guilty plea. So they put in precautions so that you can't withdraw your guilty plea. All right. So then if defendant agrees that if the count of conviction is vacated, reversed, or set aside, both the USAO and the defendant will be released from all of their obligations under this agreement. The effective day of the agreement, this agreement is effective upon signature and execution. All required certifications by defendant, defendant's counsel, and an assistant United States attorney. Breach of agreement. So then it goes into what happens if you breach. Court and United States Probation Pretrial Services. Defendant understands that the court and the United States Probation and Pretrial Services Office are not parties to his agreement and need not accept any of the United States Attorney's Office sentencing recommendation or parties' agreements to facts on sentencing factors. So they're getting prepared for sentencing, which will be, if he signed this, which will be his upcoming court date. I don't know if it will be the 13th, but hopefully it is, so the brother could get on his way. No additional agreements. Plea agreement, part of the guilty plea hearing. The parties agree that this agreement will be considered part of the record of defendant's guilty plea hearing, as if the entire agreement had been read into the record of the proceeding. Certificate of defendant. I have read it in entirety. Zaire on August the 5th, 2025. Break not the trick, signed the agreement, man. Salute to that brother, man. Prayers for him, prayers for his family. I got to know Bricc, and damn, that shit took me back, man. Just trauma, remembering how I was my son being born and my baby mama bringing Lamonte Jr. to MDC visiting. You know what I'm saying? For the first time, me seeing him because she was pregnant when we caught our bank robbery. She was 2 months pregnant. Bricc is a father. He might be a lot of things. He might have had struggle with drug addiction. He might have struggled with separating himself from people who might not have had his best intentions. He might have still suffered from post-traumatic stress because he was shot. You know what I'm saying? I'm quite sure that's one of the reasons why he had the gun. Not a justification, just survival in his mind state. You know what I'm saying? Not wanting to be shot like he was before, not being able to protect himself. You know what I'm saying? So hopefully the feds are changing that rule. I've seen things online where there's this movement to restore the gun rights of felons. I'm praying that I'm able to get that. I don't even think I could get a slingshot right now. If they had a slingshot range, I don't even think I could go there illegally. You know what I'm saying? So prayers for him, man. But that's one thing that I looked up to that dude about, man. And he's younger than me. And you can't teach me nothing about this gangster shit. I done did whatever a nigga was supposed to do in that field. You know what I'm saying? From field trips to fades to recruiting to being shot at, getting jumped, you know what I'm saying? Shoot programs, smooth programs. You can't tell me nothing, teach me nothing about being a gangster. But what you can teach me about how to be a better man. And Bricc showed me with his actions without even knowing how to be a good father. Setting an example. It's a lot of people that push the narrative about black men not being in their child's life. Every time I talked to Bricc, if he wasn't at work, except when I talked to him, he was with Vlad. So that was considered work, right? Vlad was interviewing him, right? But he was with those kids. That's what he did. You know what I'm saying? So he did some things that he probably not proud of. He felt obligated or that he needed to do for whatever reason. That's something he got to live with, something he got to figure out. But what he did do was be a father to them children. Shout out to Bricc, not the trick. Bricc, baby, man. 100 by me. I told these niggas, bro, I'm not finna say Bricc is a rat until I see some paperwork others. Documentation defeats speculation and conversation every time when it comes to that shit, man. Every time. Y'all niggas on the internet be smutting niggas' name, labeling, putting jackets on niggas like y'all didn't just see what shit he did to Nipsey Hussle, allegedly, for the exact same thing. Y'all could be on the net. Y'all don't know who gonna see you and what type of time niggas be on. You niggas just incentivized by YouTube for clicks and likes. This shit gotta stop, bro. And you niggas that get these weirdos platforms and voices, and then they run with that because they're not from our community. They believe they don't have to respect that. Yeah, you don't have to do nothing but be black and die. But understand that some of those dudes take that shit seriously, man. Bricc, baby, we just went over your paperwork, bro. Your deal is not a rat deal. You know what I'm saying? And hopefully you get the best sitting. Salute to that brother. Salute to his family. Prayers go out to him. DAMU KIWE conversation. Oh, y'all didn't know? Bricc is DAMU KIWE conversation. He part of the team. Let's go, nigga. My nigga. Bricc, not the trick. Don't see late, nigga.